Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we go and we delve into the latest news on privacy and data protection from all over the world with the Privacy Rules experts and guest speakers, depending on which is the topic. Today we are with one of our experts, which is Kelley Dickson from the law firm Macpherson Kelley from Australia, of course member of the Privacy Rules Alliance for this jurisdiction. And we're going to discuss about some recent updates coming from Australia and the practical duties or things to know for companies that might fall within the scope of these updates that we are going to receive. But first of all, Kelley, thanks a lot for being with us. It's a pleasure seeing you.
Hello, Alessandro. It's good to join you again.
Thank you, and thank you for being here. So I heard, rumors about some news coming from Australia. Can you tell us a bit more on what's happening there under the privacy perspective, of course?
Yes, from the privacy perspective, it has been a little bit busy here in Australia. And so our government is currently looking at some new legislation to implement some privacy law reforms. And these changes come from way back before 2023, when the government put out its review report in relation to how Australia's privacy and data protection laws were going. So the report was done, and then later on in 2023, the government gave its response to the privacy review report, and there were 89 proposals that the government was looking at there. And so what we've just seen introduced into Parliament here in Australia over August and September was the first round of privacy law changes in response to that. So it is just proposals at the moment, but we've got a good idea about where it looks like Australia's privacy laws will be heading.
And just quick question, how much time would you expect for this to become, applied in Australia? Do you have any idea on these?
We don't have an exact time frame yet, but if the legislation is passed in its current form, then the various obligations and changes will apply between now and within about a period of 2 years. So some will come in quickly and some will take a little bit longer.
Okay, that's a classic of those news laws, very much related to technologies in particular. And speaking about the content inside these documents you were speaking about, which are the key things that business should know about it, also under the practical perspective?
Yeah, so this first piece of legislation, we do expect there will be more, but this first piece of legislation implements 23 changes. So I won't go through all of them for you because everyone listening will be here forever. But I think the first group of changes that are important are, as you say, very practical changes for businesses. I've got 3 of those to tell you about very quickly. The first one is that businesses in Australia will be expected to put information into their privacy policy about using automated decision making. So if a business uses a computer program that either solely makes a decision or assists with the human decision making, then there will be some detail about that needs to be included in the privacy policy. Also, in relation to overseas sharing of personal information, currently in Australia, if a business wants to transfer information for processing overseas, the business has to decide and take the risk of, do we think that the overseas recipient is a good, upstanding business? The government is going to have the ability to create a whitelist of safer countries where data transfers can be made. And the third one, which I think will be bringing Australia a little bit closer to GDPR type language, at the moment, businesses in Australia have to take reasonable steps to protect information from loss and misuse and unauthorised disclosure. And that will be clarified to make it clear that reasonable steps includes technical and organisational safeguards. So that's very GDPR language.
Okay, that sounds great, and sounds like there are few similarities with other frameworks that we know well, and we also know that for the listeners that are interested, you provided us with an article that goes a bit into detail about these
Yes.
privacy updates. So we will share it, of course, together with this podcast episode. But one of the key things that normally followers are interested to hear about, because it's one of the pressing things whenever there is a new law coming or framework coming, is penalties. So how are they treated? Are there differences? Are they close to GDPR, close to other regulations? And do you think those penalties might make the difference in the future?
Yeah, the penalties in Australia are not anywhere near what we are seeing in GDPR jurisdictions, but for Australia, they have grown enormously. So over the last couple of years, we've gone from penalties that were about 2 million Australian dollars to now starting at 50 million Australian dollars, and also including things like 30% of turnover for the company. So the penalties have been increasing like that as well. But what we can also see in this new privacy reform that is proposed is a lot more power for the Privacy Commissioner. So lots more penalties, different penalties and tiers of penalties for different types of breaches. And what we're also seeing as well is the introduction of an infringement notice regime. So this is where our Privacy Commissioner will be able to deal with low-level offences and low-level issues by way of a fine, and then the business can get back to business, and then those really high penalties will apply for a lot more serious and repeated types of issues. Our Privacy Commissioner is also going to get different powers for inspection of businesses, information gathering powers, being able to force a business to do or not to do something as well. So really beefing up the power that the Commissioner has.
Perfect. I was just saying that it was interesting, the division of power and capabilities for the authorities to, treat differently cases that are indeed different, and also companies that might, be in different type of position and duties. So makes sense. My last question to you will be more general. We went to the practical, now we go back to general. Is there anything else that you believe our listeners should know, or should, let's say, highlight in their mind in particular, and check in the document we will provide, or in this new reform proposal they should know about?
There are two other quite big changes that are being proposed for Australia as well. One is a tort, the introduction of a tort for serious invasions of privacy. So this is where individuals will be able to take direct action where they think that there has been an invasion of their privacy. And that could be where someone has intruded on their seclusion, or where information has been misused, where they have a reasonable expectation of privacy, and where that invasion of their privacy is intentional or reckless and is pretty serious. The penalty for that will be up to about $500,000 Australian dollars if that is made out. And it's different depending on if the victim of that is an adult or a child. So that is something that is coming in as well. And also there is going to be introduced a criminal offence called doxing. And that is where a carriage service is used to target particular individuals or groups of individuals in a way that might be considered menacing or harassing. And that will actually have jail time attached to it as an offence. And I think what's really important for both of these is that even though these two items will be in Australia's Privacy Act, they actually will have a wider application. So the definition of personal information is wider, and the people that it applies to is also wider as well. So we're seeing privacy and data protection issues and personal privacy becoming bigger issues here as well.
That's great. I have just one quick question also on this, Kelly. You've been mentioning, those two additional, let's say, risks for company, in particular the one related to tort. I have two more questions. The first one is, are those parallel to a potential sanction of the authority, or you risk to get one or the other, because the count of the sanction that the company can receive, it becomes pretty high. And the second one is, in particular for the tort one, is this per person, or is this related to cases where there are more persons involved, and the $500,000 you were mentioning is going to be per person, or more general for more people?
Yeah, in relation to the introduction of the statutory tort, that's going to be a power for individuals. So it could be that where there is a breach, the Privacy Commissioner takes action and the individuals take action privately as well. In relation to per person and those sorts of things, depending on the type of conduct, the penalties can grow and be stacked on each other. But if it is the same type of conduct that might affect multiple people, then there would be some caps on the liability, because it would be treated as one offence.
Makes sense, but still there is a lot to care about for,
and we're getting there.
Companies. Yeah, and you're getting there. So that was very interesting, Kelley. Thanks a lot for giving us this overview on what's happening in Australia, the news that are coming. As you know, we are going to have an event. Unfortunately, we won't have you there in Paris on the 18th of November, but I really like to invite all our listeners to come and join other experts like you are to speak about topics like this during our cocktail and networking, other than the sessions where we will host guest speaker. Kelley, thanks a lot for being with us. I very much look forward to hearing some news and to meeting you soon. And thanks to the whole Macpherson Kelley team for always being with us.
Our pleasure, and we'll let you know when this is all passed.
Exactly. Looking forward to that. Let's keep us updated. Thank you. Bye, Kelley.
Bye.